So moving swiftly on to our next question that's been submitted. It asks, what legal considerations must be accounted for when engaging agency staff sponsored by third-party companies, and how can compliance be ensured?
Okay, so this is always one that I get asked quite frequently. I think when we're talking around third-party companies, and if we're using potentially, let's just say, a recruitment agency to provide our staff, again, it does interlink a lot with the prior answer with recruitment strategy, recruitment policies, etc. Because I recently advised on a case whereby that actually did go to an employment tribunal. It was with a children's home, and someone had been referred via using a recruitment agency, and they ticked all the right boxes, nothing flagged on their DBS, at least by their own admission, and within the children's home setting. When the employer, however, did a further DBS check, it seemed that there were offences of quite a serious variety as well, that would render them incompatible for the role, let's just say that. And so again, it all comes down to, are you doing your own due diligence? Are we going to take the word of a third party, or do we have our own strategy in place to make sure that, again, the person that we're engaging with is suitable? I think even for those that are sponsored, let's say, and that come over on a visa, we're working with people that are, certification of sponsorship members of staff as well. Again, we do need to be conscious that these guys are guaranteed hours at the end of the day. And should that workload decline, or, we don't have enough work for that individual, it can leave an employer in quite a bit of a sticky wicket, to say the least. And so I think it's always going to be worthwhile to consult with the business plan. Let's get a plan of action in place, and let's plan moving forward and be quite proactive with this as well. And so if we can almost plan in advance and say, right, well, this may come around the corner, we've got things such as national insurance increases naturally that we have to prepare for. Is it the right time to provide sponsorship? Is this right for the business? Because at the end of the day, it's very easy for those situations to break down and to manifest themselves in the form of a claim. Remember, the Equality Act states quite clearly that any discrimination is to suffer detriment and or dismissal on the basis of protected characteristic. And so it's very easy for myself to then turn around and say, well, I'm contracted X hours a week, I wasn't being provided these hours, I was then terminated off the back of this because of my conduct, and I don't feel that this was an authentic reason for termination. And what the employment judge would ultimately, that's presiding on that case, would be looking to determine is the principal reason for termination. And if that narrative is then spun of one of, well, actually, I feel that this was racially motivated, I feel it's because, again, I work on a completely different basis to everyone else. I was the only individual that worked on sponsorship, and I feel that I've been discriminated against. That they're extremely complex claims to navigate. So again, prevention is always going to be far better than the cure. And if you do find yourself in a situation like that, I can't stress enough, make sure that you do seek competent employment law advice based on your specific scenario and issue.
Thank you for that really detailed response. A really tricky area there, and that guidance is going to help clarify things for some people.
I hope so.
Let's